Good afternoon, everybody, and welcome to this latest episode of our podcast here at AmLaw Group, where for more than 15 years, we've been helping individuals such as yourself make a successful and comfortable transition to the U.S., whether it's through investments, business, or professional skills and talents. And today, in particular, we're going to focus on the latter. What are the options available for people, in particular, who are looking at an EB-2, EB-3 immigrant visa option? To help me with that discussion and to go in some of the details, I've invited our colleague, Asmina Simonyan, to help us work through all this. Asmina, how are you doing today? Thanks for joining.
Good afternoon, Charles. I'm doing pretty well. Thank you very much for inviting me to discuss these important questions related to employment-based immigrant petitions. How are you?
Good. I'm doing well. Thank you. And I know everybody's busy, so I appreciate you taking your time. And hopefully this is going to be an interesting episode for our clients because EB2, EB2, EB3 has a lot of misconceptions and maybe myths, we could say, around it. And hopefully in the course of the next 40 minutes or so, we can shine some light on the EB2, EB3, how they really differ. I mean, we use them in tandem. I mean, they're very similar. The primary difference is the EB2 requires generally a master's degree. EB3 requires either a bachelor's degree or could even be for unskilled workers, meaning that a bachelor's degree is not even required. But the process, the requirements more or less are quite similar or the same between the EB2 and the EB3. So for the purposes of today's discussion, we'll use those terms probably interchangeably. So one thing maybe to start off the podcast today, I wanted to talk about maybe kind of 2 or 3 really common misconceptions about EB2, EB3. And Asmina, we can maybe talk through some of these misconceptions. And maybe to start off the conversation, I want to make some clarification that sometimes people refer to the national interest waiver as EB2 as well. And in principle, that's correct. The NIW, the National Interest Waiver, is actually technically a subcategory of the EB2 category, employer-sponsored green cards. So to summarize basically what this is in a nutshell, EB2, EB3 is basically the following. You have a U.S. company that is not affiliated or owned by the main applicant, the main beneficiary. So that means you can't be an owner of the employer, or any of your close relatives cannot be owners of the employer. So this has to be really a third-party employment relationship. And this U.S. company extends a job offer to you to acquire a green card based on the fact that they were unable to find qualified American specialists here in the U.S. And that process is quite lengthy. We have to work with not only the Immigration Service, but also with the Department of Labor. And that in part explains why this whole process takes quite a bit of time. We'll talk a little bit later about the whole timing and how much time is required. But anyway, just to let you know that this is what we're talking about. This is where a job offer is extended to you, and it doesn't matter what your current status is in the U.S. You might not even reside in the U.S., or you might be here in another status. Probably the most common scenario is people come over on an H-1B, and then they get a job offer from that same employer, and they convert over to the EB2, EB3. And that option is very popular, for example, with Indian nationals. There's a lot of Indians who have H-1Bs. The problem for them is retrogression, that there's such a long line for Indian nationals. And there is also quite a long one for Chinese as well, that for people from these countries, the EB2, EB3 has really lost some of its appeal just because it's taking, 7, 8, 10 years for them to get their place in line. And so we see a lot of, for example, Indian nationals who have been waiting for years and years under the EB2, EB3, they're going to the EB5. And if you've been watching any of our podcasts, you'll hear there where we talk about we're having increasing numbers of, say, Indians who've been waiting for years for the EB2, EB3, and they've given up and, pursuing other avenues such as the EB5. But today, Asmina, I guess we're going to talk about those for whom the EB2, EB3 is a more realistic option without having to wait so long. And actually, we had some very unexpected news earlier this spring in 2026, right? In terms of the wait times for EB2, EB3s. Maybe you can say a word about that.
Yeah, absolutely. It was absolutely unexpected because the line was pretty lengthy. It was over a couple years, maybe close to 2 years, right?
Yeah.
And accidentally in February, it turned out that EB2 category became current. And following that, in March of 2026, the EB3 category became current, was EB2 remaining current. So, and for the next month, actually, we checked the bulletin. The next month looks good in terms of these categories remain current as well.
So what that means for those who might not know what this means, so you can go online, you can Google this, you could Google visa bulletin and then the month and the year that you want to look up. So you could do visa bulletin April 2026. And every month they have an update of what these lines are. And you can go in there, and as Asmina said, there was a line for years that was stretching for years. So this is going back to, I don't know, Biden's term, maybe the beginning of Biden's term. These categories, EB2, EB3, they had what's called retrogression. They were retrogressed by years. I think even at some point it was like 2.5 years possibly. So what that meant is even after you went through this whole process that might have taken a couple years and you finally got your approval, you'd have to sit and wait for another 2 years or longer after you got the approval. And this is assuming you're not from India or China or a few other countries that almost perennially always have a long line. So we're not including for purposes of this discussion, Chinese applicants, Indians, maybe Mexicans, I would think it's retrogressed too. But if you're from any other country, what this means is as of the spring, roughly March, April 2026, all of a sudden that line that was, 18 months, even 2 years, just disappeared overnight within a month. I mean, everybody's kind of scratching their heads what happened, but no one's complaining because this is obviously a big benefit for applicants out there. So that's the good news, right? Not everything in the immigration world is bad lately, right? So this is good news. These EB2s and EB3s are no longer retrogressed for most countries of the world. So that is most likely going to lead to higher appeal, maybe more applications in the near future because people just don't have to wait so long. So let's go through maybe a couple of misconceptions and then we'll dive into, the process, timing, all that other good stuff. And Asmina is going to lead us through that discussion. So maybe a couple of misconceptions that are out there. Sometimes people think EB2 is better than EB3. And I guess maybe because it's a higher number. And trust me, believe me, EB1 is not better than EB2, right? It doesn't work like that. As I mentioned, EB2 is just generally you need a master's degree or higher, or theoretically, if you have a bachelor's degree and 5 years of progressive experience, you could do an EB2. Otherwise, you'd file for an EB3. It's hard to say one's better than the other. There's really no better because in fact, you got to look at the lines and, Asmina, as you know, like sometimes we'll look and as you mentioned, sometimes, both categories will be current, EB2, EB3, and then later there might be a line in another category. So if a client could theoretically, we could write a job position that would qualify him in, one category or the other, we might do so because if we see a big difference in the line.
Yeah, true. Makes sense in terms of strategy. And absolutely, it's about maybe the eligibility, right? If the client, for some reason, doesn't have a bachelor or has his or her degree in a sphere that's completely different from what he or she is applying in the United States, he might simply not qualify for an EB2. But there is no much difference in the process, as you mentioned, Charles. Right. It's more of a, maybe.
It's a perception. Although I suppose if there's higher qualifications that are presented for a particular position, like you'd have to have a master's or you have to have a bachelor's with 5 years of experience, well, the pool of potential candidates theoretically is going to be smaller than if we say for an EB3, you just have to have a high school degree or something like that. Would you agree?
That's absolutely true. Right, because within EB3 category, for example, we have skilled, unskilled workers and professionals, and it might be really hard to prove if we're applying for a petition of an unskilled worker, right, that this candidate is for some reason much better than similar candidates applying from the United States without any skills.
Right.
And the more sophisticated these skills and education are, the easier to narrow down the pool of candidates who can potentially apply.
Here's another myth or misconception that comes up a lot. People say, hey, my work experience and job title are enough. And I know there's several reasons why that's a misconception. I would say the first one that comes to mind for me is well, is right. Education is really critical, unless this is a really low unskilled position where they just basically say, we just need a warm body and somebody that can, speak English, which is not too common. Right. What's I think is critical is that the applicant almost always has to have an educational background in that activity that they would be working in here for that position here in the U.S.
Yes, the education, if required for a certain position, then definitely must match those usually used and seen in the candidates applying for that position. So the Department of Labor here helps us to determine for a particular position what type of degree in field that degree would be sufficient. And then if the applicant doesn't have one, it might be really problematic because it's required.
And we often see that with clients. So if they, for example, and this is, I can pick on lawyers because I am a lawyer. A lot of clients, some of their potential clients come to us and say, hey, I have a legal degree, a law degree, from my home country, but I've worked the last 20 years, developing a construction business, or I've been doing IT. And we see this comes up a lot. And that can be a problem, right? Because if there's a big disconnect from your education and your experience, and let's say your experience is in IT and this employer is extending an offer to you in the IT field, but you have no education in that area whatsoever, that can be an issue that does come up.
Right. And you might be competing with candidates with that education.
Right,
And
exactly, right.
you're
And so, because we
definitely
can't
that.
just say, no, we need a high experienced programmer in this area, but they don't have to have any education in that field. I mean, the Department of Labor would probably say, wait a second, guys, you can't do that. No, they have to have at least something in maybe, data science or math or computer science. And so that would create a problem because, yes, you're going to be competing against people that do have that degree in that appropriate area. So that's one thing. Your experience and job title from your previous or current employment are great. They're good, but it's not everything. And the third item, maybe just quickly in terms of myths or misconceptions, my employer wants to sponsor me. If we've got that, the process is simple and fast from there. How would you respond to that comment?
The process is not that simple and fast as it might appear at the beginning or to many of our clients, right? First of all, it's time consuming because we can't really speed up things with the Department of Labor. We have to patiently wait and just follow the rules, follow the timeline. And basically,
It's not. You can be honest.
it's not, right? I would say without help, it might look straightforward because if someone is supporting you and guiding you, you kind of know what to expect and what are the next steps. But it's at no point it's simple, I would say.
Right. Even as attorneys, sorry for interrupting you. I'll admit it. We're human. We make mistakes too. You can't. Our viewers probably can't even imagine the degree of specificity. What you have to put in the job notice, what address you have to indicate. How many words or what information about the job can you put in there, and you shouldn't put in there. And if you don't put it in there, there could be a one or two just minor things. You got to start all over. So I would say two types of immigration probably you can't really reasonably try on your own. I would say that's EB-5 and probably EB-2, EB-3, because there's so many technical nuances. And I don't care how much you love Chat GPT and Gemini and stuff like that. It ain't going to tell you all this stuff. It really isn't. So yes, unfortunately, it's not simple. It's not really fast. And we'll talk about the timing in a moment here. And here's the good thing though. But if you do have an employer that's willing to sponsor you, that's maybe half the battle. Right? Because I think that's something we run into a lot with our clients, potential leads or clients that come to us and say, hey, can you help find an employer for me? And we say, unfortunately, we're not a job search agency, right? We can't help you find the job. If you can find that job and they can make an offer to you, then great, we'll take it from there. But believe me, it can be difficult because think about it, right? If you're, a real bona fide employer, not everybody's willing to wait 2, 3, 4 years for you to get your green card. Now, if you have work authorization currently in the U.S. and you can currently work for that company, sure, then they might be willing to wait. You can work for them in the meantime, but it can be difficult finding that employer. And here's one thing, maybe this is our segue maybe into the next discussion here, but what is required of the employer? Clients often ask this. They might say, hey, I've got an employer who's ready to do this, but he's scared about the paperwork and all the requirements and stuff like that. Maybe you can say a few words, Asmina.
Usually, the employer is required to participate, be involved, I would say, in the recruitment process because the Department of Labor processing, like the prevailing wage determination or PERM certification, for example, we as attorneys, as a law firm, help them, right? But if it comes to recruitment, it's something that the employer has to do to interview candidates and to take some time to review their resumes, to collect the resumes, even though we do provide guidance and support in terms of all the advertisement, because the process is pretty complicated and you gotta know where exactly to post your ad, what to include in that ad. And as you previously mentioned, Charles, just little things, maybe meeting travel requirements or insurance might cost you years. That's when you're required to start over, right? You're losing this time. So at this point, I would say the recruitment process is the most important part where the employer is required. Other requirements are probably the ability to pay wages is also a very important thing, and your employer must be able to onboard you when the time comes and pay you the wage, which must be no less than the prevailing wage determined by the Department of Labor.
Right.
And apparently stay in business, because when the time comes, the employer must be operating company, right? That can still continue with the process. And
Exactly. So I think the summarize what you said, the dummies version of the detailed explanation you gave, Asmina, is there's not a whole lot that's required of the employers. We will guide them. There are some things that they have to do, right? They have to interview the most qualified candidates. We can't do that for them. Nobody else can. They have to
True.
maybe post the job announcement at their place of work. They have to do a couple other things. But in terms of like labor intensity and stuff like that, no, there's not a whole lot. And I think probably the biggest consideration when an employer is looking about going forward with this for an employee, the biggest consideration is whether the employer can prove ability to pay. And that's something you mentioned as well, that what the employer has to do is show for that year, in that year that we're starting the process when we file the prevailing wage determination, we have to show that the employer has enough money to pay that wage. Now, when we embark on this journey, we don't know what that is. Right? We don't know exactly what the wage is that the Department of Labor will set for this position. And we'll get to that in a moment here. You probably have to mute that. I suppose it's mute up with beeping. I thought that was my phone. Is that your end? I think it's on your end.
Yeah, it's mine. So
Okay, so mute that if you can. So I'll go back here. So the important thing is that the employer shows that it has the ability to pay the wages. Now, we don't know exactly what the wages are when we file everything. We know roughly what they will be. We have a band, a range that we can tell the employer and the employee what that will be. But until we actually get it from the Department of Labor, we don't know exactly. But, plus or minus, I mean, how much is the difference? Is it plus or minus maybe 10, 20,000, maybe 30,000? I guess depending on the range.
roughly, yeah, we can estimate at least. Yeah,
Right,
using
right.
the Department of Labor tools, we can estimate the
Yeah.
amount.
You got that guy there? Are you okay with the phone? Or we probably have to mute it or something.
Yeah.
All right.
Oh, it's muted. It is. Yeah.
But I can still hear it, huh? No? Or is it my end? Or see that you hear it just now?
Oh, yeah, right. I heard. This is the watch. Just give me a second. Sorry, Charles.
Oh, that's a watch. Okay.
Yeah, because I muted everything. I was surprised. Where does this come from? Okay, they're off. Sorry.
Okay. All right.
Yeah.
So what we're talking about? The wage.
In terms of, we don't know.
Yes, we
We
don't
can
know.
estimate
You're
10
right.
to 20,000. Yeah.
So we can only make an estimate as to what that amount is. And then once the Department of Labor indicates what that is, then at that point, the employer needs to be able to show ability to pay. Now, that doesn't mean literally they have to have that cash sitting in a bank account. Generally speaking, it's okay. It's sufficient if the employer can show in their tax return for that year that they had enough net earnings that year to cover the salary. So if the Department of Labor says, hey, you have to pay this guy $100,000 a year, then it's sufficient for the employer to then show in their tax return for that year that they had earnings of $100,000 that they could then use to pay for that employee's wages. So again, you don't have to show a bank statement with a balance sitting there. Here's the other thing too that makes the job a little bit easier. If that person is already working for you, let's say in an H-1B capacity or maybe as an E-2 holder, then that salary gets taken into account. Right. So if you're already paying them $100,000 and let's say your profits are only $40,000 for the year, that's not a problem because you're already paying that person $100,000, granted in a different status. So that makes the financial burden a little bit easier. So let's talk about the process here. Let's do a deep dive into the process, Asmina, as to maybe we'll just do a top level overview of what's required. So we started talking about what this thing's called the prevailing wage determination. So that's usually what everything starts with. That's where we have to prepare a job description, right, for this potential employee.
Right. That's where we need to think thoroughly and basically about the duties, the proposed duties and candidate requirements, and make sure that our candidates can meet those requirements with the experience and education that he or she possess. So this
Right.
is a very important stage, I would say, because based on that, first of all, Department of Labor will determine how much the employer must pay these candidates, such candidate with such set of skills and qualifications for the job duties, proposed job duties. And secondly, we can't change things later on without losing time. So it's very important to make sure that the applicant, if he or she possesses that experience, can easily prove it with some letters from prior employers, for example, and education requirements with the degree that he or she has.
Right.
If the degree obtained from some foreign institution, we usually do have clients to evaluate their diplomas to match them to the U.S. equivalent.
So the prevailing wage determination, and in principle, this is how it works in reality. In principle, we're reverse engineering the job position in vacancy. So we're saying that if the clients come in and say, hey, I want to hire this person, Bob Smith from Canada, and Bob has this type of education and this educational background and this type of experience, et cetera, then we wanted to create that job description and educational requirements that reflects that person's background, right? Because it doesn't make sense if they want to hire this person and they have a background in engineering and we say, no, we want somebody, in, foreign languages. It doesn't make sense. So the reality is we kind of prepare that job description based on the client or candidate that the client has in mind. And you would think that's kind of a straightforward process, but it's not. It's pretty intensive, labor intensive. It takes, weeks, even a month, maybe longer to kind of get that right. Because again, if your description of the job is too complicated and it makes it sound like this is a really high level job, then you're going to get a really high salary, which most people generally don't want, right? And it's just the opposite. If you dumb down the job too much and lower the requirements, you're likely to get more applicants for the job. And theoretically, maybe one or more of those applicants would be qualified. And therefore, it would be difficult to prove that, hey, we really need to hire this foreign employee. So there's a balancing act that's involved. Just from our years of doing this, we kind of know you want to make this sound like a higher level management executive position, or you want to dumb it down, but you got to try to find the sweet spot in there. So we start with the prevailing wage determination, like you said, Asmina. Let's say that takes a month or two to prepare. We send that to the Department of Labor. How long do we have to wait to get a response from them?
Usually, we are getting the response within 4 to 6 months. Sometimes it comes back sooner. Sometimes we have to wait a little longer, but usually within the 6 months time frame, we are able to receive the actual prevailing wage determination, telling our clients, the employer and the employee, how much the employer must pay. I mean, this is the minimum wage that the employer can offer to the employee throughout the process in order to succeed with this application.
Right. So we get that. So now you can see this is just the first step, folks, right? This is the first step. And that alone,
Yeah.
it's 4 to 6 months just to get feedback from the first government agency. So let's say it was 6 months and we get a response back and they say, hey, you got to pay this person $100,000. What's the next step then, Asmina, after that?
The next step would be to perform a recruitment in the United States. This is where the employer comes in place and basically starts to be more involved in the process. So depending on the type of application, here where the slight difference can be seen in EB2, EB3 applications, because usually for EB3, for skilled workers, professionals, less advertisements required. For example, we don't have to proceed with extra steps. We are just good with 3 mandatory steps, which is an advertisement on a state workforce agency and notice that needs to be hung on a wall at the place of employment, proposed employment. And the third one would be a newspaper. When it comes to an EB2 or any occupation that requires a bachelor or higher, we do need to also place advertisement in 3 additional media sources, for example. So at this point, it's a little, I wouldn't say more complicated, it just takes more time, and we advise clients on what media sources or other acceptable sources can be used. And the faster the employer, or maybe it depends, the length of the process really depends on how fast the employer can place all ads that are required. I would say the shortest one should be in place as a notice for 10 business days. The rest of the advertisement, the longest one, needs to be placed on a website for approximately 30 days. Meaning that the longest for 30 days, if we start on day 1 with all advertisements, or say within the first week we start and we post all ads, it means that by the end of the first month, maybe 1 month and a half, we are done with all advertisements and we can proceed with the actual interview process at this point.
So, and here, just to keep in mind, like, you're not obligated to choose if you have to, for example, advertise on other channels, like Asmina mentioned, other websites. You don't have to pick, the best out there, right? Indeed, for example, I think Indeed is a very good recruiting website. You're not obligated to spend, have a monthly spend of $1,000 to promote your ad and get the maximum number of recruitments or applicants. So again, we have to follow the requirements, but we don't necessarily have to go above and beyond what those minimum requirements are. So then let's say they put the ads out there for 4 to 6 weeks, however long they needed to. And let's say they got, 50 applicants back.
Fortunately not. Yeah. If the applicant doesn't possess the required education, for example, you can cross that application out without even conducting an interview. You can just inform your applicant that for some reason he or she wasn't picked, and you can move forward. And the Department of Labor won't punish you for that and won't see it as discriminatory at this point, right? But in case the applicant possess probably education and set of skills that might be aligned somewhat with the candidate requirements, to be on a safer side, you should conduct this interview and make sure that what is written on the resume, because not necessarily what's on the resume can be supported by references from prior employers, right? Or by interviewing that candidate, you may figure out that probably he doesn't possess that level of expertise that was initially shown on the resume. So yeah.
So what? So
Not
I guess
everyone
there's
has to
no
be
magic answer, right? To say, okay, if you got 50 responses to your job notice, we're not obligated to invite 20% in, 30% in for an interview. Is there any kind of defining factor? Or I guess what you're saying is you've got to look at each individual, and even out of those 50, let's say 40 of them seem like they're qualified. They have the required education, and they theoretically have the corresponding experience. So in that case, you might be obligated to even bring in, 20, 30 people for interviews. I mean, I shouldn't scare people away. That's never happened. I can't recall
right.
it ever happening with any of our clients.
It's a rare occasion. That's sure. And basically, even if you schedule your interviews either offline or online, many people may not even show up, right? For some reason.
Mhm.
The fact that they apply doesn't necessarily mean that the interview will happen eventually. But as a bona fide employer, you'll have to offer them that interview in case they're somewhat qualified.
And you can always do the interviews in Zoom
Yeah, and
or Google Meets and stuff like that. There's no requirement how long it has to be, 30 minutes, 60 minutes, But what's important here is the record keeping. So you need to keep good records as, who applied for the job, who did you disqualify right off the bat because they didn't have enough education, or in your view, they didn't have corresponding experience. And you got to keep records of all this because why? Because there could be an audit subsequently, right? They're going to want to see your analysis. Why, did you not invite these people in for the interviews? Why did you think this person was not qualified, et cetera? The default case is you don't have to provide that underlying supporting documentation, right? Generally, we can just say, hey, we followed the process, the procedures, we couldn't find anybody who was qualified, but we have audits. Audits are done. I don't know what the, percentage is. I mean, it's a fraction of a percent. It's not like it's very, very common, but there also are certain cases that might be more likely to trigger an audit. Again, we're maybe not attuned to what all those factors might be, but if they see some kind of red flags or some kind of suspicious activities or something or whatnot, that's more likely to trigger an audit than not. And anyway, in addition, like keeping records also, so you have to keep records of those that you disqualify, and then also keep records of the people that actually come in for the interview. I mean, you keep records of who you invited. Maybe 10% don't even show up. The remainder, you have to keep records of, okay, why did this person, after the interview, were they qualified or not qualified? And if you felt they weren't qualified, you have to keep some notes why, that's the case. So at the end of this whole process, what's the goal? The goal, I guess, is to show that there weren't any qualified applicants, right?
qualified candidates. Yes, right. And you mentioned it correctly, Charles, that record keeping is very important at this stage because it's normal to forget things, and in a month or two, you may not remember how many interviews you conducted, what was the reason, and who were the candidates. But we are helping our clients, and so we developed a spreadsheet with a very detailed one that the employers has to follow and insert information following each interview, which is pretty straightforward, and this can be kept as a record, like a summary of everything that happened, and in case it's needed at a later stage, it can be easily retrieved and remembered from that documentation.
So then if we take it the next stage, and let's say they did the interviews, and we and our client feel comfortable that there really weren't any qualified applicants who applied, we kept records of it, et cetera, et cetera. At that point, I guess we do what's called the labor PERM, right? And that's where we submit the documents to the Department of Labor for them to review.
Right. For a particular candidate that we picked, which is our candidate, and we are basically letting them assess, evaluate the candidate to make sure he or she meets the requirements and is the best candidate for the position based on education and set of
Right.
and experience, actually. Yeah.
Right. So we
So that's
basically
what
show
we
we
do.
went through the whole process. We couldn't find anybody, but here's, John Smith from Canada who, here's his background, here's his education. We'd like to get approval for his petition, right? Is that how it goes?
Right. He's
Okay.
the best fit. But this is the time-wise the lengthiest part of the process because here we can't do anything but wait for the Department of Labor to certify this form, the PERM, and get back to us
And how
so
long
that we
does that
can move
take
forward
usually?
with the next steps. Well, I would say from what we've seen recently, somewhere from 12 to 15 months.
Months, right? Yeah. So everybody's clear now. We're looking at this. Okay, we're a month or two to prepare the PWD, the prevailing wage determination. Then we're 6 months to get that response back. Then we've got 2 months to do the recruiting. Then and it could be longer actually. Then we file the
Yes.
PERM. Yeah, the PERM, that, like Asmina said, that could be 12 to 15 months, could even be longer. So, this whole process, as you can see, because of all the government agencies involved, is not fast. So then they'll get back to us at some point, maybe in a year, in a bit, and say, hey, sure, you followed the procedures correctly. Your candidate is qualified and we approve the PERM. What happens at that point?
Once it's done, we are free to file an I-140, which is an immigrant petition for alien worker. At that stage, it can be expedited by paying a premium processing fee. We can expedite it to 15 business days within which the USCIS must review the application, get back either with an RFE if they miss something, they would like to look at certain documentation to confirm our candidate's experience or education, for example, or issue an approval. And
So
here,
here's
it
the thing.
really
Like
depends.
you said, premium processing, 15 days. That's great news. Clients always say, hey, I got 15 days. Why don't we do premium processing? But you got to understand, before that premium processing, you've probably been waiting at least a year and a half, maybe 20 months, maybe even 24 months. So it's like a long wait time. And then we're kind of like almost at the finish line. And then at that point, we can expedite it. Oh,
True, but that's even that is not it, right? Because getting your I-140 approved, as you previously mentioned, Charles, with that backlog that we've seen in the past, the retrogression that existed, it didn't necessarily mean that you're good to go and now you can apply either for an adjustment of status if you're in the country or undergo consular processing.
line, you only get your place in the line, that's where the waiting starts when you file that I-140. So that's the other thing too. You might have been working on this, the PERM, the PWD. This was a year and a half, 2 years. That means nothing as far as the immigration service goes. You only get that place in line when you file the I-140 on January 1st, 2027, whatever it is, right? That's kind of the date from which they're going to calculate. So like you were saying, us meaning the retrogression. Currently, there's no retrogression. So it means as soon as you get your I-140 approved, you can take the next step. But if retrogression occurs again in the future, and it probably will, if they might come back and say, oh, we're only reviewing cases from 2026. We haven't even gotten to 2027 yet. In that case, you might have to sit and wait a little bit.
Wait, that's why we're so excited about this retrogression disappearing overnight, because that means as soon as your I-140 is approved, you can move forward with the next step, which is your green card process.
Right. The only downside of that is just make it clear to people who maybe didn't understand. The thing is, we just can't go out tomorrow and file your I-140. So the people that today aren't subject to this wait time, they need to have started this whole process, a year and a half ago, such that they've done the PWD, they've done the PERM, and now they're ready to file the I-140. And lo and behold, there's no wait time. So again, people that are benefiting from this lack of retrogression are people who started this process, maybe a year or two ago. But it's never too late to start, right? Because who knows, the line might stay down, it might grow a little bit. It's always moving. So I can't discourage people from filing right now. We would file right now. We would only be a year and a half or so from now when we get to the point where we could file with the immigration service. But the longer you're putting off getting a decision.
Yeah,
on all of this.
the best time to start is today. That's true.
Yeah, that's right. Carpe diem. So let's talk briefly. We have not too much time left, but just briefly, what kind of evidence is required? So you talked about we have to prove the education. So if there's an education requirement of the position, client has to provide, a diploma. If that diploma is from overseas, we do an equivalency. That's not difficult. It's not expensive. That's pretty straightforward. How do we prove?
Job experience is usually proven by letters from prior employers, preferably on the company's letterhead, signed by the company's HR or executive. It's very important that the experience is proven by third parties, not by the applicant himself or herself. That's where it becomes a little complicated when, for example, we have clients who used to run their own sole proprietorship, right, in some countries. So they weren't acting as a real legal entity, and they really didn't hire people and didn't have any executive or HR personnel working for the company to confirm that. So the only way for them would be to draft letters from their own name to confirm their experience, which is not that credible piece of evidence as it should be at this point. So it's recommended that the letters are from any third party.
Right.
It can be an employment book. Some countries that maintain employment books.
Sometimes, like you said, it could be letters from clients, if there's major clients, from some third parties that we can try to prove that this person was engaged in this activity for this period of time.
Right. Maybe even colleagues sometimes. So yeah, but
Co-workers.
usually most of the time, co-workers, yeah, we use letters as proof with a detailed description of the duties performed and the timeline, the position for the applicant to confirm that experience in the past.
Right. What's required from the employer, then the U.S. employer, like I said, the main requirement is showing that their ability to pay. And like I said, usually that's done through tax returns. And generally they'd have to show the tax return for that year when they got the prevailing wage. So as you recall, I talked about, it might take a year and a half to get, through this whole process. They again, they look at the point in time or the year when we filed the prevailing wage, or actually when it got filed or when it got approved? I guess I can't recall. Do you know when the prevailing wage is approved or filed? I think it's when it's filed that they look at. I could be wrong.
I believe filing.
Yeah, I kind of think so too. So again, and here's the thing, right? The reality is, like any business cycle, businesses go up and down. There might be a recession. You might have a big decrease or increase in orders. And there's ways to get around that though. Let's say you had a really slow year. There was a recession. You lost a really big client. There are other ways to prove the ability to pay. Some of those other ways include, like if the company has assets, there's a certain ratio you apply. Like if you have to show ability to pay $100,000 salary, I can't remember the exact ratio, but I think if you can show like 500,000 in assets, that is in place of having, revenue of that amount, because they can say, okay, you've got assets. Granted, these aren't necessarily liquid assets. If you sell them tomorrow, you're probably going to lose some money. But anyway, there's a ratio you can apply. So historically, I don't recall we ever had any problems with this per se. Worst case scenario, they could make an additional contribution to the capital of the company too. If, hey, they said, you had a bad year, there's no capital or assets of the company, there's no revenue, any of the shareholders or members could make a capital contribution to, the company as well to prove the ability to pay. So that's usually a resolvable issue. Was there anything else, Asmina, that we need to mention in terms of documentation?
In terms of, I would probably add a note regarding those letters of recommendation at this point, because it's not merely about confirming that a person worked for a particular employer during a certain period of time. Sometimes clients misunderstood the assignment and misunderstand the assignment, and they're thinking about recommendation letter, that this was a great worker, he performed well during this period of time, right? But what the Department of Labor and USCIS are looking to see there is basically a very detailed duties that must be aligned and confirmed and must be aligned with the candidate requirements for a position that the candidate is being sought at this point.
Right.
Yeah. So it's very important to, in terms of other documentation, these are major parts that must be provided from employer employee. And as soon as they are met, we don't need any extra paperwork.
Absolutely.
And
So
whatever happened, no, I just wanted to add you, the recruitment process is also usually not getting attached in major part to the actual I-140 application, unless, as you mentioned earlier, there is an audit.
Right. So basically they kind of trust everything that we've done properly, but if they feel they need to double check it, then they would request an audit. So I guess to summarize that, we just need to have a clear, consistent story about what the job requirements are, that they match the candidate's background, education, stuff like that. We could do a couple scenarios, but before we do that, just wanted to touch on a topic that does come up a lot. What happens when things change, right? Life changes, business changes. Employer might go out of business. Employer might change their plans, right? They might say, hey, we just don't have the money to hire you anymore, or we just don't want to hire you, even if we do have the money, right? So those things can affect things. Or let's say the candidate relocates and is no longer going to work in that same city. So Asmina, we don't have time maybe to go into all these different permutations and circumstances and stuff like that, but we can maybe briefly discuss some of the main issues. So let's say, for example, somebody has an approved I-140, but then their employer goes out of business, closes up shop, or just decides they don't want to work with you anymore or hire you. What are the options for the applicant?
At that point, if there is an approved I-140, then the applicants actually can't change employer, because at this point, if I-485 has been pending for more than 180 days, then theoretically the portability rule may apply. Not theoretically, but actually, and in fact, it will be applied, and the employee can change the job point.
Right. So it's got to be a job. It's got to be basically the same job title, same job application, requirements, et cetera, et cetera. Has to
Duties,
be
yes.
in the same location, general metro area, because what salaries are in Miami and what they are in, Ames, Iowa are significantly different. So it's got to be in that same, area and the same, job title, et cetera, et cetera. But yes, you can take advantage of that portability if you had that I-140 approval and you've been waiting for your adjustment of status for more than 180 days. There's also a situation where this is a little bit different, where let's say this happens with a lot of people, they might have filed for their EB2 or EB3 quite a while ago. Often happens with Indian applicants. They've been waiting 5, 6, 7 years, and they're tired of waiting. You could, and we've had this recently, if the client is talented or skilled enough, they might be skilled enough to apply for an EB1A. It doesn't require an employer, but what the advantage is you're able to use the priority date from your previously filed EB2 or EB3, and you can kind of port over that priority date to another EB category. And so it could be EB1, for example. And then that would allow, if the line for EB1As for Indians is much shorter than it is for EB2s or EB3s, that would allow them to take advantage of that and basically kind of skip the line because they had been waiting all that time. That basically they get credit for waiting in that line, even if they switch over to a different category that doesn't even require an employer. So there's just too many factual circumstances to go into right now. Suffice it to say, there are options. I've even heard of people that, I believe it was before they even got the approved I-140, or maybe it had been approved, but they hadn't been waiting 180 days, and the government still honored the situation. So the government sometimes, under the current administration, we shouldn't expect much flexibility. But in the past, if there were circumstances beyond the control of the applicant, then sometimes the government would kind of, be magnanimous and allow them to go forward with it anyway. So again, this is a very fact-specific scenario, and we'd have to go into all the facts in order to, give meaningful advice. So to wrap up this session, Asmina, maybe let's go through a couple, kind of like, we call this our Blitz analysis, kind of a green light, yellow light, red light scenario. I'll give you kind of a quick scenario. You can tell me, hey, is this a green light situation where, hey, no problems, we can do it? Yellow light, maybe it's resolvable theoretically. Red light mean, no, this is not going to fly. So let's go with scenario number one. Let's say we've got an applicant. It's an E2 position, or EB2 position, but the applicant doesn't have a master's, but he or she has a bachelor's degree and 5 years of progressive relevant experience. Would that work for an EB2 for someone like this?
It would work if 5 years of progressive experience occurred after the bachelor degree was obtained by the applicant, and it can be proven with documentation that we discussed before, like letters from prior employers confirming detailed duties, position, and the period of time, and also confirming if it was a full-time employment, so that it can be easily calculated and proven that 5 years of progressive experience the candidate actually have it, and it occurred after the bachelor was obtained. So I would say it's more of a green one.
Yeah, pretty green.
Paperwork, can be obtained, and there are no issues with confirming prior experience.
So that's an interesting thing that surprisingly that comes up sometimes, where people got they had the experience and then they went back to get the degree. That's a problem. That experience has to be acquired after the degree. So that's maybe the main point. Hopefully we want people to take away from that scenario. Let's say, what if somebody says, I don't have a degree, but I have lots of years of good experience, and in reality they have strong experience. Is that person even eligible for an EB2 or EB3?
Well, it really depends. If a position that is picked for an EB3, for example, doesn't require a bachelor, but it requires a certain set of skills that our applicant possesses, and a high school diploma, for example, as an entry, as an entry to the occupation, for example, it can be done. So we can basically proceed with a high school diploma and set of skills and qualifications that this applicant possess in order to qualify him for a job. But it's very important that this job, according to the Department of Labor handbook, does not require a bachelor.
We can't just go out there and say, here's an IT programmer, but we don't want an IT programmer with a bachelor's degree. We don't need it. No, you're bound by what the Department of Labor handbook requires.
Yeah.
Here's a question. Can you substitute education with experience for like an EB3? They have no bachelor's. Can they, if they have like 20 years of experience, can that substitute?
Well, for an EB,
Not an EB2,
you
I'm sorry.
can't do it.
EB3.
Yeah, EB3. Well, sometimes it can be done. Usually they count it as 3 years of experience equals to 1 year of education. And if you have more than 12 years of experience, you can theoretically prove that you have bachelor in the field. I mean, in case you worked in the sphere of your expertise, right, and you have proven record of such employment, then it can be done.
Last, maybe a quick scenario. What if we've got an employer who's willing to serve as a employer, but it's a startup company, or maybe the job roles at the company are constantly changing because it's growing so quickly and changing, and this month they might need a software developer, next month they need instead senior VP. Is that doable?
Well, it depends on the role of a particular applicant for whom the application, the process with the Department of Labor had started. We can be changing. We can be looking for an architect and changing to a VP within the same set of documents, right? We got to stick to a role that was picked initially, but as long as at least the location, the description of duties, the employer's location remain the same, because it's crucial. The Department of Labor, like you previously said, will determine the wage based on the location of the employer, and it can be really changed much without triggering the whole new process, right? The need to start the whole new process. So at this point, as long as that employer can really prove that their ability to pay wages, if you're not yet employed with them, then probably, and they're not changing a particular position requirements and the location, that should be doable. It really depends on a particular situation, but yeah.
Right. So we need, the important thing to keep in mind is you can't change the job title and the duties and stuff like that on the fly. So in any kind of growing company, there's flexibility that's inherent with that. But as far as EB2, EB3 goes, you got to kind of lock it down. Okay, we need this position with these job duties, and you got to ride it out. And for that 2 years, 3 years until you get through the whole process. That's what's important to keep in mind. There is no requirement that the company be operating more than a year, 5 years, stuff like that. It could be a startup. So the mere fact that it's a startup, that's not a problem. Again, as long as it can prove the ability to pay. And like Asmina mentioned too, location is important. You can't change location, the description, other job requirements and stuff like that. But assuming, at least for this particular applicant and person you're trying to help, you're able to stick with a particular, vacancy, job title and duties, then it shouldn't be a problem. So as we probably learned, this is not a very simple process, and hopefully our viewers can appreciate that sometimes it can be a somewhat boring topic, very technical, but for people who are looking at doing EB2, EB3, I think some of these issues we've talked about today are extremely important. And I think the biggest takeaway for our listeners today is you really need to talk to an experienced attorney at the outset before you even get started to make sure, when you start on this road that's going to take a year and a half, 2 years, possibly longer, you want to do proper planning at the outset to avoid any problems that could come up in the course of the engagement. So with that, maybe we'll wrap up today's discussion. If you are looking at an EB2, EB3 for yourself, employees of your partners, feel free to reach out to us to have an individualized consultation where we can talk about some of these nuances. There might be some other avenues that are available besides EB2, EB3, or we can focus on these visa options to make the process as smooth as possible. Thanks again, Asmina, for your time.
Thank you, Charles, for this interesting discussion. And I really hope that we were able to provide some clarity on certain aspects of the process to our viewers.
Absolutely. So I think we that part of the mission was accomplished. And so hopefully this was educational and informational for all our viewers. And again, until we see you next time, I look forward to talking to you all again. This is Charles Raether from AmLaw Group. See you soon.